Bismillah ar-Rahman ar-Rahim. Today we are going to complete our explanation for the relationships between the executive branch, the executive managers of executive governmental organizations, and the judiciary. Last topic we talked about last week was that about the Chevron, and very interesting and important to know that even though the Chevron allow public administrators to explain or act on the intent of the legislation, and in that doing they enact a legislative action. But however, as the final point we explained that of particular interest are the cases in which the court determines that the agency has misinterpreted or gone beyond the intent of the legislation. And a good example here is the legislation creating the Safety and Health Administration, known as the OSHA, which is a part of the Labor Department, criticized the agency that it has gone beyond the legislation intention regarding the setting of standards for handling hazardous materials. Handling the hazardous materials falls under the auspices, under the jurisdiction of the OSHA at the workplace. The agency standards, the OSHA standards, were set to guarantee that employees will not suffer diseases, cancer and the like, due to the exposure to the hazardous materials. And the American Petroleum Institute is like a good example here. It sought judicial review regarding the new standards which were set by the OSHA that led the courts to a discussion of two rather interesting issues. One aspect of the case had to do with the legislative intent. The Fifth Circuit Court focused on this issue and finding that the phrase "to the extent feasible," that phrase in the legislation means that a standard had to be both technologically and economically feasible. And the Supreme Court concentrated more on the health aspects of the case, with the majority concluding that existing standards were not dangerous and the new standard was not necessary. The justices who dissented argued that the court should not substitute its own judgment on the technical merits of the case for that of experts within the agency. The case illustrates several of the most important difficulties that face the courts in reviewing administrative actions. Concerns for due process. At the heart of the system of jurisprudence is the assurance that people will be treated fairly, that they have a right to present arguments and evidence in their own behalf, and that those who make the decisions will be unbiased and impartial. As with issues of due process in administrative adjudication, whether a hearing is required, at what point, and the format of the hearing, some patterns have emerged in the Supreme Court's evaluation of administrative matters. The court sought to protect the rights of citizens from arbitrary action on the part of administrative agencies by requiring that a person be allowed an opportunity to challenge a proposed action before being made to suffer serious harm. The court would not allow cost or inconvenience to the agency as an excuse for causing harm to an individual. Through the 70s and 80s, the Supreme Court began to alter its approach to administrative due process, treating administrative hearings not as a means for protection, but as a device for fact finding. Most frequently, the court has employed a balancing test, weighing the interests of the individual, rather narrowly defined, the value of additional safeguards, and the government's interest, including the physical and administrative burdens that additional procedural safeguards might impose. As a result, it has become much more difficult for someone who feels that adequate protections have not been provided to prevail in the courts. The flexibility in administrative law for due process has contributed to a variety of alternative dispute resolution (ADR) strategies, namely mediation and arbitration. In fact, the adoption of the Alternative Dispute Resolution Act of 1990 helped remove many of the barriers administrators face to such alternative approaches. For the most part, the ADR strategies are easier to employ in less complex cases. Yet, ADR should not be used to obtain settlements that fail to protect the public interest. That's very important to remember. The spirit and letter of the agreement must be clear, or else face considerable challenge and potential failure during the implementation stage. The courts and agency administration. Over the past 20 to 30 years, one of the most dramatic developments in the relationship between administrative agencies and the judiciary is the direct involvement of district courts and some state courts in agency administration, including decisions on spending, personnel, organization, and management. This involvement has come about through court rulings in administrative equity cases, wherein individual rights, such as the prohibition against cruel and unusual punishment, has been violated by state and local administrative organizations. Two landmark cases in the early 70s set precedents for such rulings. In the first, prisoners in the Arkansas penitentiary system alleged a large number of abuses, including dangerous and unhealthy conditions in the prisons. The court ruled that confinement in the Arkansas system amounted to cruel and unusual punishment, and ordered corrections officials to devise a plan to remedy the problems. Similarly, in Alabama, a federal district court judge found intolerable and deplorable conditions in the state's largest mental health facility and ordered corrective actions. The court also established a constitutional right to treatment, detailing actions required to meet that constitutional standards. The involvement of courts in the management of public agencies is especially well illustrated in a federal judge's order demanding reform of the New Orleans Parish Prison. In addition to ordering adequate medical services, improved security, and development of recreational facilities, the judge directed that the management and operation of the prison be improved immediately, that a professional penologist be hired to manage the prison, and that personnel practices, filling vacancies, raising wages, etc., be improved in specific ways. Although court actions such as this have obviously corrected constitutional inequities, there are questions as to whether the courts are well suited for involvement in the details of administration. Moreover, many states and localities argue that court-ordered expenditures of funds on projects such as desegregation or prison reform take money away from other needed services, such as education, social welfare, or even mental health. Indeed, for these various reasons, the Supreme Court has recently taken steps to limit the involvement of courts in the work of administrative agencies, requiring carefully tailored plans of limited duration based on specific constitutional violations. And now it will be very beneficial for you to summarize what we said so far. We explored the political context of public administration, including things you will simply need to know to operate effectively in or with public or non-profit organizations. The material we discussed so far constitutes a knowledge base on which to build your action skills. Understanding the political context of work in the public sector will enhance the effectiveness of your actions. Public managers and their counterparts in non-profit organizations work in many different institutional settings, but those institutions all reflect important political values that lie at the heart of a democratic system. Whether at central governorate or local level, in the governmental or non-governmental sector, democracy's values, especially a concern for operating in the public interest, affect the structure of public and non-profit organizations. For example, the division of powers at the central level expresses a fear of concentrated power. And finally, the structure of non-profit organizations reflects their operation in the public interest. Knowing something about how democratic values are reflected in the structure of the various organizations, and knowing something about the role of executive leadership in administrative organizations will enable you to act with greater confidence and authority. As a manager, you may have important interactions with a legislative body, either the parliament, a governorate legislature, a local city council, or a non-profit organization's board of directors. Those serving in the public interest participate in one way or another in nearly all policy areas, a situation that our political system encourages. The distinction Woodward Wilson suggested, which we mentioned at the beginning of the lectures, between politics or policy and administration no longer accurately describes the relationship between the legislative and the executive branches. Today, the legislature and the various agencies of government share the policy process, either working together in developing policy or making separate decisions in different realms. And that concludes the material we intended to explain. During the coming few days, I'm going to develop some research topics for you to work on. And you're going to have until the 7th of June, I think, to turn in your research papers. And while working on them, I want you to take good care of how you are going to introduce the research. You're going to have an introduction which should exemplify, which should describe and stress on the importance of the topic you are going to research, and then start to review the topic first in terms of points, the important points you are going to explore, and then have a body for the research where arguments are presented, and make sure that you are going to reference the sources you are going to get your information from, and think carefully about the points you presented and how you explain them, and try to tie them all together in a conclusion for the research. And the conclusion will be the last part of the research, where you are going to draw the big picture, which include all the points you addressed and you researched and you explained in a whole coherent way, and that will inshallah make you pass the course, and hopefully we'll see you next week, and hope to see you all in the second year.